Well, howdy, folks, and welcome on in to the American Law Café. Go on and pull up a chair, get comfortable. Today, we're going to be talking about something that gives every trial lawyer nightmares, and that's the art of the appeal. Now, I want you to picture this. You're in that courtroom. The jury just came back, and they read the verdict, guilty. And your heart just sinks right into your boots because you just know, the judge made a huge mistake, a fatal error that cost you the entire case. So what now? Is it over? Is there any way to fix this? Can you possibly save your client on appeal? Well, the answer to that terrible scenario, like most things in the law, it all comes down to the rule book. And for us, that's the federal rules of evidence. You got to think of these as the official rules of the game for any trial happening in a federal court. So these first two rules, they kind of just set the stage for us. Rule 101 is as simple as can be. It tells us where we're playing this game. U.S. federal courts. Easy enough. But Rule 102, now that's the heart of it. That's our mission statement. It tells us the whole entire point is to be fair, to be efficient, and most important of all, to find the truth so we can get a just result. That's the star we're all steering by. Okay, now let's get into the real meat and potatoes, because this right here is where it all happens. Rule 103 is, and I'm not exaggerating, maybe the most important rule a trial lawyer has. It's all about preserving your one shot to get a mistake fixed on appeal. And if you mess this up, well, there's usually no second chances. See, the thing is, not all mistakes are treated the same by the appeals court. There are really three main flavors. First, you've got harmless error. Sure, the judge messed up, but it didn't really change anything in the end. The conviction stands. Then you've got prejudicial error. Now, this is the one you're looking for. This is a mistake that was so bad it affected a major right and probably did change the outcome. If you save this one, you've got a real shot. And last, there's plain error. This is a mistake so bad, so obvious that an appeals court might just fix it even if you didn't say a word. But darling, you do not want to bet the farm on that. That's a Hail Mary, plain and simple. So how do you protect that precious prejudicial error? Rule 103 boils it down to two things you absolutely must do. These are non-negotiable. First, when the other side tries to introduce some piece of bad evidence, you have to object. And you got to do it right then and there. And you have to say exactly why it's wrong. Second, if the judge blocks your evidence, you have to make what's called an offer of proof. All that means is you have to tell the judge, for the record, what that witness was going to say or what that document was going to show. If you don't do these two simple things, your appeal is pretty much dead on arrival. Now, talk is one thing, but let's look at some real-life stories from the courthouse. These are cautionary tales about how perfectly good appeals were lost right there on the trial floor, all because a lawyer forgot these simple basics from Rule 103. Let's kick things off with a case called State v. Torres. It was a DUI case, and the prosecutor puts in some paperwork about the defendant's prior convictions. The defense lawyer, he doesn't do a thing, just sits there quiet as a mouse. Then, way later, when he's giving his closing argument to the jury, he decides now is a good time to argue that the paperwork wasn't properly authenticated. So what do you think the appeals court said? You guessed it. Too little, too late, counselor. The time to make a fuss is the moment the evidence is offered, not when the trial is practically over. The whole point is to give the trial judge a chance to fix their own mistake right there in the moment. By waiting, that lawyer in Torres just completely waived the whole issue. Gone. All right, but what about when it's the other way around and it's your evidence that gets shot down? For that, let's look at Alley versus State, a first-degree murder trial. The defense lawyer is cross-examining a witness, trying to show the jury he told a different story before. The prosecutor objects. The judge says, sustained. Boom. Evidence blocked. And what did the defense lawyer do? Nothing. He just moved on to the next question. And this just shows you the mistake in black and white. Look at what he did versus what he should have done. Instead of just giving up, all he needed to say was, Your Honor, may I make an offer of proof for the record? That's it. Just a few simple words. That would have let him tell the court what the testimony was going to be, creating that all-important record for the appellate court to look at. But because he stayed silent, the appeals court had nothing, absolutely nothing to review. The lesson from Alley is a harsh one, but it's a simple little piece of math. No offer of proof means there is no record of the excluded evidence. No record means there's nothing for the appellate court to even look at. And no review means you lose. It's as simple and as final as that. So what happens if you try to do everything by the book, but the judge just flat out stops you? That brings us to our most extreme case yet, State versus Gaylor. Here, the defense attorney was trying to cross-examine the alleged victim about something she'd said that didn't add up. The judge shut him down, so the lawyer, doing exactly what he's supposed to, says, "Your Honor, I'd like to make an offer of proof." And you know what the judge said? No. He refused to even let the lawyer make his record. Now, this right here is so important because it sets down a powerful rule. The appeals court in Gaylor came down on that trial judge like a ton of bricks. They said, listen, a judge can absolutely keep evidence away from the jury. That's their job. But what they cannot do is keep that evidence out of the official record for an appeal. When a judge blocks a lawyer from making an offer of proof, they make a fair appeal impossible. And that, my friends, is what we call reversible error. Gaylor's conviction was thrown out. All right, so we've seen how you can lose an appeal one mistake at a time. But these rules don't live in a vacuum. What happens when they all start interacting in the chaos of a real trial? To see that whole picture, we're going to look at a case called State v. Brown, a double murder trial where rules 104, 105, and 106 all had a big role to play. So here's the setup. You've got two people shot and killed with a .22 rifle. The man on trial is Amos Brown, who was the victim's nephew. The prosecution's star witness? His buddy, a co-defendant named Harold Melton. And the entire case really hinges on this very detailed written statement that Melton gave to the police, a statement that points the finger right at Brown. First up, Rule 104 comes into play. This is the rule about preliminary questions. You can just think of the judge as a gatekeeper. Before a jury ever gets to hear a piece of evidence, the judge and the judge alone decides if it's even allowed in the courtroom. In the Brown case, a detective overheard the defendant making some comments on the phone, so the judge, using his power under Rule 104, had to decide first if those comments were admissible. He decided they were, and only then did he open the gate and let the jury hear them. Next up, Rule 105, which is about limiting evidence. See, sometimes evidence is good for one thing, but could be really unfair if the jury used it for something else. That was definitely the case with Melton, the co-defendant. He was testifying as part of a plea deal, which means he had a really good reason to lie to save his own skin. The judge couldn't just throw out his testimony, but he could put some guardrails on it. So he gave the jury what's called a limiting instruction. He basically told them, folks, you can listen to what this man says, but because of his deal, you need to look at his testimony with a whole lot of extra caution. And here's where things got really interesting, all thanks to Rule 106. We call this one the rule of completeness. During cross-examination, Brown's lawyer thought he was being real slick. He started reading just a couple of out-of-context bits and pieces from Melton's written statement to try and make him look like a liar. Well, the prosecutor shot right up out of his chair and invoked Rule 106, which is basically the no cherry-picking rule. He said it's not fair for the jury to just hear one little piece of the story, they deserve to hear the whole thing. The judge agreed, and just like that, the entire very damaging statement was read to the jury. So the big takeaway from State v. Brown is seeing how all these rules work together like a machine. If you try to cherry-pick a statement, Rule 106 lets the other side bring in the rest of it for context. And if you're going to fight any of these decisions on appeal, well, you better have made a good, clear record with a timely objection, just like Rule 103 tells you to. Brown's lawyer failed on that point with some other evidence, and the appeals court basically just had to shrug its shoulders and say, sorry, can't help ya. So we've gone through all these rules, all these real-life cases. What's the one thing, the final takeaway you really ought to remember from our little chat today? I'm going to leave you with this question to mull over. We started out talking about Rule 102 and how the goal of all this is supposed to be finding the truth. But what we've seen today is that the legal system doesn't really run on some kind of abstract, cosmic truth. It runs on what a lawyer can prove, and maybe, even more importantly, what that lawyer properly preserves in the trial court record. It's a pretty sobering thought, ain't it? Well, that's all the time we've got for today here at the American Law Café. If you enjoyed this explainer, we'd sure appreciate it if you'd hit that like and subscribe button. And for more talks like this, you can find the American Law Café anywhere you get your podcasts. We'll see y'all next time when we'll break down another piece of this big old legal puzzle.